Alrighty, welcome everybody, my fellow emoluments and of course others. This presentation is going to be, of course, as titled on notices. Primary source materials are going to be from the Mason's Manual of Legislative Procedure and of course the law dictionaries as Black's Law is one pictured. Pardon me. Because notices are the first thing you have to do when you commence any process, right? So you got to know what a notice is, which is a legal notification, right? Required by law or agreement, or imparted by operation of law as a result of some fact. So predicating on that pretty much right off the bat, we'll just go ahead and dive right into it. Conditions of which there are 5, right? So, and it's, you have some actual knowledge, right? You have received some information, right? You wish to report about something. You have a reason to know. What's your reason to know? You know about a related fact. How do you know about it? Is considered as having been able to ascertain whatever it is by checking an official filing or record. Verification of something. So, as notices are mandatory, even in the 10 principles of group decision making. So whether you're in a quorum or whether you're in any of the other 2 pillars, me, of course, being in the executive branch, hence my oath of office, notices are mandatory, right? It is what it is. So a notice of the meeting must be given to all members of the group. So whether it's a quorum or whether it's some other form of process, notices, of course, are mandatory, beginning with the first pillar. Why? Because a concealed intention is an evil one. Whoops. So in so much as notification to public emoluments, you can't legislate for us in all cases whatsoever. Remember the law? These are two declared acts of tyranny, conduct of tyrants that can definitely get you discharged from your emolument. So if you're doing anything that looks anything like these or any other conduct that is declared conduct of a tyrant, quit doing it. Pardon me. So actual notice. What is actual notice? So this is notice given directly to or received personally by a party, also termed express notice. In property, it is notice given by open possession and occupancy of real property. So what are you actually noticing? In this particular instance, we're going to talk about actual fraud, right? So actual fraud is a concealment or false representation through an intentional or reckless statement or conduct that injures another who relies on it in acting. Also termed fraud in the fact, positive fraud or moral fraud. So what would that look like? There's typed out for you. So basically, when you commence process in a republic, right, your notice should look like something like this, right? Because if you're talking about a transaction, the House of Representatives controls the purse. So if there's some kind of fraud that has to be discharged or dismissed relating to a transaction, your responsibility is to submit it to the House of Representatives first. If it doesn't get discharged, then you move through the process. But simultaneous service to the executive, whether it be directly to the governor or the lieutenant governor, or if there's a respective overseeing agency such as Secret Service. Secret Service has operational control or prosecutorial discretion, as it were, and with anything related to fraudulent transactions, right? So if we're talking about known theft, okay, if we're going to be prosecuting anybody, they have to be notified. That comes in the form of a suspicious activity report, or SAR. The as you follow the process, right, attached to your notice is going to look something like this: a motion and further clarification of what process it is you wish to follow. Again, the law says instruct your representatives. Well, open the book, Mason's Manual, section 632, right? You got to have that initial meeting to discuss who's going to be doing the reporting. So here's what that motion would look like. So you're talking about page 563, number 10, which is an investigation into the management of the various institutions of the state and the departments of state government is at all times a legitimate function of the legislature. So what we're mandating they do is investigate the emoluments they've created, whatever that investigation is going to reveal. So the comprehending the fact that these Sharia law actors, they disappear into a star chamber and they are claiming some power that we know they don't have. Well, again, see the video on Due Process 2.0, and we'll clarify that for you. Adequate notice, advance notice, notice given beforehand, right, by some specified amount of time. Sometimes erroneously written advance notice. So maybe these examples are not the best, but you get the general idea. Commercial law notice under the UCC code, and of course, constructive notice. Me being me, having a little fun with the picture. Hence constructive notice. What are they constructing? Because apparently you can't go anywhere. Sounds a lot like family court. Direct notice, due notice. What the government said, well, I don't yield my authority to an agency that serves me, period. Count on that. So that would be a form of an actual notice, picture notwithstanding. So actual notice is actual notice of a fact that is brought directly to a party's attention. Don't touch me there, right? Sufficient and proper notice that is intended to and likely to reach a particular person or the public. Notice that is legally adequate given the particular circumstances, also termed adequate notice. We have enforcement notice. Again, couldn't resist. Express notice and fair notice. Fair notice is kind of one of the ones I want to focus on here a little bit. Sufficient notice apprising a litigant of the opposing party's claim. Right? Say, well, hey, look, don't say I didn't warn you. I gave you fair notice. So, when you hear me use those types of terms, trust me, I know exactly where they fit and why. So the requirement that a pleading adequately apprise the opposing party of a claim. For example, you ever walk into a courtroom and a bar member says, oh, by the way, here's your service. You're already sitting in the freaking chair. It's happened to me. I know it's happened to many of you. Something else, a little comfort zone. They might as well get used to not having that available option anymore, because that's going away. Hence the reason behind this slide. So, immediate notice. This is notice given as soon as possible, more commonly, and especially on notice of an insurance claim, notice that is reasonable under the circumstances. Don't touch us there, period. You ain't going to like the end result. Implied notices, imputed notice. So implied notices. What's an implied notice? Yeah. These are some things. Speaking of the Declaration of Independence, you're going to sit in an office of public trust and tell me you've never read your state's constitution or the Declaration of Independence or the United States Constitution and that you're qualified to sit there. No, you're not. So this is an implied notice. Reading means reading. Notice that is inferred from facts that a person had a means of knowing, and that is thus imputed to that person an actual notice of facts or circumstances that, if properly followed up, would have led to a knowledge of the particular fact in question. Pick up the damn law and read it. Moving on. An inquiry notice. You're going to get a lot of these from me. These are generally referred to as a parliamentary inquiry or some other request for information will be attached to this notice. So if you get an inquiry notice from me, chances are I'm doing some oversight or I'm auditing you for some reason. So this is a notice attributed to a person when the information would lead to an ordinarily prudent person to investigate the matter further at the time at which the victim of an alleged securities fraud became aware of facts that would have prompted a reasonable person to investigate. So, again, as this was always part of my job, if I even got a memo, hence the joke, didn't you get the memo? Yeah, that's where that joke comes from. So when I come in and I start to commence my rising and reporting, that comes from parliamentary law, right? Excuse me, parliamentary law of a special committee that has exhausted its business to dissolve and send a report to the referring body. That would be to the quorum, the entire quorum, further up and down. A committee's rising is equivalent to a deliberative assembly's adjourning sine. So this is me basically meaning without delay. That's what that means. No state shall convert a liberty into a license and charge a fee thereof. Murdoch versus Pennsylvania. Period. Rising and reporting on that. If a state converts a right or liberty into a privilege, the citizen can ignore the license and fee and engage in the right or liberty with impunity. Shuttlesworth versus City of Birmingham, Alabama. Decided in 1963. Don't like it? Too bad, so sad. Judicial notice. Legal notice, which is, of course, also referred to as constructive notice, due notice, right? Public notice, notice by publication. That would be a form of a newspaper article, some other form of notice. Personal notice, oral or written notice. That's going to be what you're going to get from me. Personal service, personal notice. Positive notice. Presumptive notice, which is, again, we just covered that. So public notice. This is notice given to the public or persons affected by publishing a newspaper of general circulation. This notice is usually required, for example, in matters of public concern. So, reasonable notice. Notice that is fairly to be expected or required under the particular circumstances. It is what it is. Here's some examples of public notice. Your publications. I'm seeing a pattern form here. Every time the government decides it's probably not a good idea to touch us there, this is pretty much the public's reaction. So, again, going back to the 1930s, this is not our first rodeo here. Record notice, short notice. Record notice is constructive notice of the contents of an instrument, such as a deed or mortgage, that has been properly recorded. There's also such things as notice of liens, right? Notice of the, that are also recorded notices, right? Or record notices. So if you're going to place a lien on somebody or something, you have to record that and serve, right, a record notice. So short notice, this is notice that is inadequate or not timely under the circumstances. Like I just said, walked into court. Well, by the way, here's your service. Don't get me started. So intellectual property, I'm not going to go into that because we're not talking about patents. We're talking about transactions here. So we're sticking to the subject matter. But I did put in the entire notice of, the every definition of notices I was able to find in Black's Law. But I'm going to stick a little bit here with parliamentary law because that's where we are. Parliamentary law, which is a meeting's published call, right? A formal statement that certain business may come before a meeting, usually made at an earlier meeting or published with the call of the meeting that will consider the business and made as a prerequisite of the business consideration. Sorry, got stuff going on here in the office, so I'm trying to keep that stuff down. So anyway, we have the verb translation of the word notice. This is to give legal notice, right? Or to realize or give attention to, right? Hey, what's going on in here? Notice and comment period. Again, this is now we're getting into administrative law. Administrative law is not something that I'm very happy about. Administrative law, that's stuff that we do on the clock, specifically related to things like, shipping, receiving, business, inventory, transactions, not people. People administrate their own business, not bar members. Certainly not any other foreign emolument. Statutory time frame during which an administrative agency publishes a proposed regulation and receives public comment on the regulation. You can expect a whole lot of repeal here. So a notice of filing, this does not mean what you think it means. A lot of people have said notice of filing is you're informing the attorney or some other party of this notice of filing. Well, according to the dictionary, that's not what it means. So according to the dictionary, this related to transactions. So if you're going to get a notice of filing from me, it's good because I'm going to challenge something with your transactions. Typically as a description, number 4, as a description of the types of or items of collateral. Also referred to as a collateral matter. Notice of abandonment. When you do not respond, you can expect a notice of abandonment, specifically referencing number 2, property. A formal announcement, usually in writing and recorded, that a person is relinquishing a claim to personal or real property. You can count on that you're going to get one of these notices from me. So if you receive a notice that you better do something, you don't do it, you can expect to be discharged. Notice of alibi rule. The principle that, upon written demand from the government, a criminal defendant who intends to call an alibi witness at trial must give notice of who that witness is and where the defendant claims to have been at the time of the alleged offense. Seems reasonable. Can't be in two places at once, can you? The government is in turn obligated, there's a word, to give notice to the defendant of any witnesses it intends to call to rebut the alibi testimony. Sounds like they're arguing over exculpatory evidence, Brady information, doesn't it? Moving on. Notice of allowability. This is getting into patenting. Again, if Issues relating to patents, that's going to be another presentation for another day. But notice of allowability relating to patents, just be mindful that it is a thing and it does exist. So notice of allowance, patents, trademarks, that kind of thing. Well, this office, E-Clause, LLC, that trademark in the upper right corner, again, right? So that's a good example of what a trademark would be and how to use it. Notice of appeal. This is pretty self-explanatory, right? A document filed with a court and served on the other parties stating an intention to appeal a trial court's judgment or order. You've received my notice of appeal. You've received my notice of appearance, right? Procedure. A party's written notice filed with the court or oral announcement on the record informing the court and the other parties that the party wants to participate in the case. So it is what it is. You can either allow it or not allow it and then be impeached. I don't care. But no, it's coming. This monopoly crap ain't happening anymore. Notice of completion, usually in construction law. Again, this is when you get your building is completed and you now have your certificate of occupancy and, all that good fun type stuff. Another commonly misused notice is a notice of dishonor. This is a notice to the endorser of an instrument that acceptance or payment has been refused. This notice, along with the presentment and actual dishonor, is a condition of an endorser's secondary liability. And there you can find it in the commercial code. So again, if you're talking about commerce and business, right, it is what it is. Notice of incomplete application. Again, patenting. Not applicable under the thing of, oh, somebody didn't inform me, right? That's a insufficiency of service, insufficiency of process. So please do not confuse the two. Notice of lis pendus, basically meaning that you're going to inform somebody of a pending lawsuit, right? Notice of motion. That's that certificate of service that's usually at the back side of every motion, right? So that's why I said these things go hand in hand, and these come from the rules of the common law. So notice of responsibility. Again, this is construction law, not what you're thinking it is. This is a written disclaimer that, if posted conspicuously and recorded, relieves a property owner from liability for work or materials used on the property without the owner's authorization. Usually comes in the form of you see a lot of this, especially with easements, utility companies, that kind of stuff. So notice of orders or judgments, that one is pretty self-explanatory. It is what it is. So I'm going to cover this one last time. Statutes are not law. Statutes do not create jurisdiction. There it is. I don't need to go ask the judge. I can get that right from the rules. So I have a case that supports this rule, which was an easy way to challenge it. So instead, there are mechanisms to enable federal courts to hear the cases that are already within their original jurisdiction. So if this is a state case, what are you using a federal court mechanism for? Just putting that out there. Notice of pendency. Notice of, prior art references. Again, getting back into patents. The law specifically dictates that person is entitled to their respective intellectual property rights for whatever the limited time is, and you have to renew your patent or whatever it is every so often. It is what it is. So in lis pendus, this is a pending lawsuit, as I just got done saying. the jurisdiction, power, or control acquired by a court over a party while a legal action is pending. That's why I said this office's jurisdiction is under 28 USC 1443, right? That is an acquired power. A notice recorded in the chain of title to real property. Again, we're not talking about a real property transaction here. So this is your definition right out of the law dictionary of what your notice in lispendus actually means. So again, for further clarification, I took the liberty of scanning this for you. You guys can read this. James W. Eaton's Handbook of Equity and Jurisprudence. Good read, by the way. Highly recommend it. Notice of protest. Statement. This is a statement given usually by a notary public to a drawer or endorser of a negotiable instrument that the instrument was neither paid nor accepted, information provided by the drawer or endorser that protest was made for non-acceptance or non-payment of a note or bill. Wait a minute. That means somebody's got a job to do here. Perfectly within the scope and authority of the emoluments of this office. So it's right there in the book. Don't need a judge to verify that. Pick up the law dictionary and go verify it for yourself if you don't believe me here. I'm just trying to make life easy on you. Notice of removal. Marble in the ashtray notwithstanding. So the pleading by which the defendant removes a case from state court to federal court, which is exactly what we did in the Altenhofen case to get this jurisdiction. Somebody at state level fell outside the supreme law of the land and minimum due process requirements. Notice of responsibility. So written notification by a government agency informing the recipient of a time-sensitive obligation to take some specified action, such as controlling noxious weeds, remediating a contaminated area, refraining from bringing alcohol to a space rented from the government, reimbursing court-appointed counsel and dependency proceedings. I'm saying that one's going away. They can take that Sharia law crap. If I didn't hire you, you're fired. Notice of trial. Self-explanatory. Document issued by the court. Notice of pleading. Notice prejudice rule. This is a doctrine barring an insurer from using late notice as a reason to deny an insured's claim unless the insurer can show that it was prejudiced by the untimely notice. Take these notices directly to the House of Representatives, because these insurance companies, which are bankers, by the way, that's where they report. That's, again, back to the legislature. That's why they're there. Noticing statutes. Excuse me. Noticing statutes. We're going to start discharging these. Pretty much probably all over the place. Because, again, who's writing these statutes? Not our legislators, not in the first pillar. Not me, not in the second pillar. Not a judge, definitely not in the third pillar. So those got to come from the monarchical bar members and their, how did Bill Barr say it? Atavistic and wrong-headed thinking when he spoke to the Federalist Society. So again, it is what it is. You can take your statutes and go back to the monarchy if you want to go live in a monarchy. You're not doing it here. Forget about it. Notice to admit. Notice to all the world. I think I just did that. Moving on. Notice to appear. Bring your happy butt. Bring your papers. Your voluminous records. For those of you who have seen Common Law Due Process 2.0, you'll know exactly what I'm talking about. Notice to creditors. Wait a minute. Pay attention, student loan folks. this is a little worse than going to a drive-through and not getting your French fries. How many years did you spend in that thing called a university and didn't get taught what you went there to learn? I would think the fundamental foundations of law and government and how to actually work a transaction and what the emoluments of government are and your relationship to them. I would have thought that would have been required reading. Moving on. Notice to pay rent or quit. Notice to plead. Now, notice to quit, pay rent or quit is to a lesser or leaser, lessee or lesser or lessee that you're intending to move for whatever the reason. Notice to plead. You're either going to plead it or you're going to deny jurisdiction. Period. Rules of civil procedure. There they are. Matter of fact, civil procedure 4A. And if we're talking about civil procedure anyway. So there's your notice to quit. This is a landlord's notice demanding that the tenant surrender and vacate the leased property, thereby terminating the tenancy. It is what it is. So demand for back payment of rent, send those demands to the legislature. It is what it is. They're supposed to be the ones paying the bills here. Notice to treat, English law. In the exercise of its compulsory purchase power, an authority's invitation to negotiate given to the owner of an interest in the land that the authority seeks to acquire. Right? Been to a few of these meetings. What's the main motion? Number 24 out of the Mason's Manual. The main motion, is the main question presents a bill, resolution, or other substantive proposition for passage, adoption, approval, or rejection. There it is. So if you are just going in there to pay a bill, you enter that in under a motion 24. They already know what they're supposed to do with that stuff. If they don't, hand them a book. So first impressions count. When providing any form of a notice, defined or not, it is very important to observe the closest definition, provide source if possible, to what will be easily comprehensible to those with which you will be communicating for the duration of whatever the project or process may be. Right? So here's two principles with which to remember. Excess in law is condemned, and too much subtlety in law is condemned. What's the happy medium? Have fun with that. Thank you for your attention, and I hope you found this review helpful. Look forward to seeing you guys on the show.